he hears it in South Carolina when he practices. Attorney John Mobley with us on the show today. John, you've been in that courthouse, I'm sure, many times. Have you heard it? Is this common in South Carolina?
I'm familiar with it like everyone else, but I mean, it's somewhat of an antiquated concept. You know, there are a number of evidentiary legal principles that have been developed through the case law over the years, but those principles were developed prior to the codification of the rules of evidence. So the rules of evidence, you know, are really what controls in a situation like this. You know, because you hear what you've heard over and over from the attorneys and the judges, Rule 403, you know, which has to do with prejudice, and 404B, which has to do with prior bad acts. So while I think it's interesting that Judge Newman, in his research, was able to reference the res gestae case law, I don't think that's going to be controlling. I mean, what's going to be controlling is the codification of rules of evidence, which is 403, which has to do with the prejudice, and 404B, which has to do with the analysis for admitting prior bad act evidence.
Exactly. You're absolutely right. Those rules, and if they're talking about any hearsay, 803, as you know, John, right? Those are the rules. As you said, the codification happened later, and that's really what governs. So a little law school lesson. Thank you for adding to it, John Mobley. Stand by.